The knock on my door came at exactly 7:30 on a Tuesday morning, which should have been my first warning that something unpleasant was about to happen. I had just poured my second cup of coffee and was looking forward to a quiet breakfast before heading to my workshop when the sharp, insistent rapping began. Through the frosted glass, I could see the outline of two people standing on my porch, and something about their rigid postures told me this was not going to be a friendly visit. I opened the door to find a woman in her mid-50s with an aggressively styled blonde bob and lips pursed so tight they had practically disappeared. Behind her stood a nervous-looking man in his 60s holding a leather portfolio like it was a shield. The woman's eyes swept over me with undisguised disapproval, taking in my worn flannel shirt and paint-stained jeans. "Franklin Yates?" she asked, though her tone suggested it was more of an accusation than a question. "That's me," I said, taking a sip of my coffee. "What can I do for you?" "My name is Patricia Hendricks, and I'm the president of the Meadowbrook Heights Homeowners Association. This is Gerald Morrison, our treasurer. We need to discuss an urgent matter regarding your property." I lived on 20 acres of wooded land in western Massachusetts, about 5 miles outside the town of Northampton. My great-grandfather had built the original farmhouse here in 1923, and I had spent the last 3 years renovating it after inheriting the property from my father. The nearest neighbor was half a mile away, and I had deliberately chosen this isolated location to avoid exactly the kind of people who were now standing on my porch. "I'm not part of any homeowners association," I said flatly. Patricia's smile was as warm as a January morning in Vermont. "That's actually what we need to discuss. The Meadowbrook Heights development was established 2 years ago on the adjacent property, and according to our survey, the only viable access road to several of our lots runs through your land. We're here to formalize an easement agreement." I set my coffee cup down on the porch railing and crossed my arms. "Let me get this straight. You built a development next to my property, and now you want to use my private road." "It's the only practical solution," Gerald interjected, his voice apologetic but firm. "The alternative would require us to build a new access road at considerable expense, and the terrain makes that extremely difficult. Your road already exists and connects directly to the main highway." "My private road," I emphasized, "that my great-grandfather built, on my land." Patricia's expression hardened. "Mr. Yates, we're trying to be reasonable here. We're offering fair compensation for the easement. This benefits everyone. Your property value will increase with the development nearby, and we're only asking for limited access to 3 residential lots." "3 lots now," I said. "What happens when you decide to expand? What happens when your homeowners start treating my road like a public thoroughfare?" "We have very strict rules," Patricia said primly. "Our covenants, conditions, and restrictions are extremely comprehensive. We maintain high standards in Meadowbrook Heights." "Good for you. The answer is no." Patricia's jaw clenched. "I don't think you understand the situation. We've already sold those lots. The buyers are expecting to break ground this spring. If you refuse to grant the easement, you'll be interfering with lawful commerce and causing significant financial harm." "That sounds like a you problem," I said, picking up my coffee cup again. "You should have secured the access rights before you sold the property." "Now, if you'll excuse me, my breakfast is getting cold." "We will pursue legal action," Patricia said, her voice rising. "You can't simply refuse to cooperate with the community." "I'm not part of your community. I was here first. And yes, I can refuse. It's called property rights. Have a nice day." I closed the door before she could respond, though I could hear her sputtering indignation through the wood. Gerald said something in a low, calming voice, and eventually I heard their footsteps retreating down the porch steps. I watched through the window as they climbed into a silver Lexus SUV and drove down my driveway, Patricia gesturing animatedly the entire time. I should have known that wouldn't be the end of it. 3 days later, I found a certified letter in my mailbox. The return address was from a law firm in Boston, Sterling, Whitmore and Associates. I opened it standing right there at the mailbox, the morning sun warm on my shoulders despite the lingering chill of early March. The letter was exactly what I expected. A formal demand that I grant an easement across my property to provide access to lots 47, 48, and 49 of the Meadowbrook Heights development. They cited various legal precedents about landlocked property and reasonable use. They mentioned the substantial investment made by the development company and the homebuyers. They used phrases like good faith negotiation and equitable solution, while making it very clear they were prepared to take me to court if I didn't comply. The letter also mentioned that the HOA was prepared to offer $25,000 for the easement, which they described as generous compensation well above market value. I had to laugh at that. My privacy and the integrity of my property were worth a hell of a lot more than 25 grand. I took the letter to my own attorney, a sharp woman named Rachel Zimmerman, who had handled my father's estate. Her office was in a converted Victorian house in downtown Northampton, all hardwood floors and tall windows. Rachel had been practicing law for 30 years, and I trusted her judgment completely. She read the letter twice, her reading glasses perched on the end of her nose, before looking up at me with a thoughtful expression. "They don't have a strong case," she said. The landlocked property argument only applies in specific circumstances, and even then, the courts try to avoid forcing easements on unwilling property owners. The fact that they created the problem themselves by selling lots without secured access significantly weakens their position. So I can just tell them to take a hike, legally, yes, but understand that this will likely get expensive and unpleasant. HOAs can be remarkably persistent, especially when money is involved. They'll drag this out, file motion after motion, try to wear you down. Even if you win, which I believe you will, it's going to cost you time and legal fees. "I don't care," I said. "That road is important to me. My great-grandfather cleared the path by hand. My grandfather paved it in the 50s. My father and I repaired it together the summer before he died. It's not just about property rights, it's personal." Rachel nodded slowly. "Then we'll fight. But I want you to do something for me first. Go through any old property documents you have. Deeds, surveys, anything from when your great-grandfather first acquired the land. Sometimes there are details in the original paperwork that can strengthen your position. Old property rights were often more explicitly defined than modern ones." "I have boxes of old documents in the attic," I said. "I've been meaning to organize them since I moved in, but I kept putting it off." "Now you have a good reason. Look for anything that specifically describes the road or access rights, anything that establishes the historical use of the property. It'll be helpful." That evening, after finishing work in my furniture workshop where I built custom cabinets and tables, I climbed into the attic with a flashlight and a growing sense of dread at the task ahead. The attic was hot and dusty, filled with decades of accumulated family history. Old furniture, trunks of clothes, boxes of photographs, and yes, several filing boxes crammed with documents. I started with the box labeled Property Records in my father's neat handwriting. Inside were layers of papers, tax records, insurance documents, utility bills going back decades. Beneath those, I found older survey maps, property tax assessments from the 70s and 80s, and finally, wrapped in oilcloth at the bottom, a thick bundle of papers tied with string. The string disintegrated when I touched it, crumbling into dust. I carefully unfolded the papers, my heart beating faster as I realized what I was looking at. These were the original property documents from 1923, including the deed executed when my great-grandfather, Frederick Yates, had purchased the land from the previous owner. The paper was yellowed and brittle, the typing faded but still legible. I read through it slowly, my eyes adjusting to the formal legal language of the era. The deed described the property boundaries in meticulous detail, using landmarks and compass directions that would have been accurate a century ago. But it was the third page that made me stop breathing for a moment. There, in precise legal terminology, was a clause specifically reserving all road and access rights to the property owner in perpetuity. The language was remarkably explicit. The grantor hereby conveys to Frederick Yates and his heirs and assigns the below-described parcel together with all improvements thereon, including but not limited to the private carriage road constructed by the grantor in 1920, which private road shall remain under the exclusive control and use of the grantee, his heirs and assigns, in perpetuity. No easement, right-of-way, or access right shall be granted, implied, or construed to burden said private road for the benefit of any adjacent or neighboring property, now existing or hereafter created. I read it 3 times to make sure I understood it correctly. My great-grandfather had specifically negotiated language to prevent exactly what the HOA was trying to do. The road was explicitly private, with no possibility of implied easements or rights of way. This was better than I could have hoped for. I carefully photographed each page with my phone, then carried the original documents down from the attic and placed them in a document protector. First thing Monday morning, I drove to Rachel's office and handed them over. She put on her glasses and began reading, and I watched her expression change from professional interest to something approaching delight. When she finished, she looked up at me with a genuine smile. "Franklin, this is remarkable. This kind of explicit language is extremely rare in deeds from that era. Your great-grandfather must have had good legal advice. This absolutely confirms your exclusive rights to the road. No court is going to override language this clear. So what do we do now?" We respond to their demand letter with a firm denial, citing this deed language. We make it clear that you have historical, legal, and explicit deed protection of your road rights. We also point out that they created their own problem by failing to secure access before selling those lots. With this deed, I don't think they'll want to take this to court. Any judge would rule in your favor. Rachel drafted the response that afternoon, and I approved it the next day. She sent it by certified mail and email to Sterling, Whitmore and Associates, and then we waited. The response came faster than I expected. Only 2 days later, Rachel called me with an edge of anger in her voice that I had never heard before. "They're not backing down," she said. "I just got off the phone with their lead attorney. He claims the deed language is outdated and doesn't apply to modern property law. He says they're prepared to file suit arguing that the explicit reservation of road rights is an unreasonable restriction that effectively landlocks their properties. They're also threatening to sue you for tortious interference with contract because their buyers are getting anxious. That's insane. The deed clearly states, I know what it states, and legally they don't have a leg to stand on, but that doesn't mean they won't try. Some attorneys operate on the principle that if you throw enough legal motions at someone, they'll eventually give up just to make it stop. It's a war of attrition." "Let them come," I said. I'm not giving in, but the HOA had other tactics beyond legal threats. 2 weeks later, I discovered what they were willing to do when I drove down to my mailbox and found Patricia Hendricks standing there with 3 other people. A man in an expensive suit who I guessed was one of the lot buyers, another middle-aged woman with a tablet, and a young guy with a camera. Patricia's expression was triumphant in a way that made my stomach sink. "Mr. Yates," she said loudly as I got out of my truck, "we're here conducting a public inspection of what we believe to be a historical county road. We have every right to be here." "This is a private road on private property," I said, keeping my voice level despite my rising anger. "You're trespassing." "We have documentation," the woman with the tablet said, stepping forward. "County records show this road predates your property boundaries and may have been designated as a public access way in 1919. We're simply exercising our right to investigate potential public easements. Let me see that documentation." She held up the tablet, showing me what appeared to be an old survey map, but even from several feet away, I could tell something was wrong with it. The lines didn't match the terrain and the date was suspicious. "That's fake," I said bluntly. "Excuse me." Patricia's voice dripped with false offense. "Are you accusing us of forgery?" "I'm saying that document doesn't match the actual county records. I have the original 1923 deed that explicitly describes this road as private property, constructed in 1920 by the previous landowner. Your map claiming it's from 1919 is either a forgery or a deliberate misrepresentation." The man in the suit spoke up for the first time. "My name is Robert Chambers, and I purchased Lot 47 based on the HOA's representation that access was secured. If you're preventing me from accessing my property, I have grounds to sue you personally for damages." "You have grounds to sue the HOA for fraud," I countered. "They sold you landlocked property. That's not my problem." "We'll see what the court says," Patricia said. "In the meantime, we're going to document this entire road. You can't stop us from walking on what may be public property." "This is private property. You're trespassing. Leave now or I'm calling the sheriff." Patricia pulled out her phone. "Go ahead. We have a legal right to be here, and we have documentation to prove it. We're not leaving." I pulled out my own phone and dialed the Franklin County Sheriff's Department. The dispatcher answered on the second ring, and I explained the situation calmly, giving my address and describing the trespassers. She said a deputy would be there within 30 minutes. "You're wasting everyone's time," Patricia said, but I noticed she looked less confident now. "We'll let the deputy decide that." The young guy with the camera had been recording the entire interaction. Patricia kept glancing at him and then at me, clearly trying to provoke a reaction that would look good on video. I refused to give her the satisfaction. Instead, I leaned against my truck and waited. The other people with Patricia seemed increasingly uncomfortable as the minutes ticked by. Robert Chambers kept checking his watch and muttering something about a meeting. The woman with the tablet had put it away and was nervously fidgeting with her phone. Deputy Marcus Johnson arrived 28 minutes later in a marked sheriff's vehicle. He was a solid man in his 40s with a calm, professional demeanor that I immediately appreciated. He listened to both sides of the story, examined Patricia's alleged documentation on the tablet, and then asked me if I had proof of ownership. "I have the deed in my house," I said. "The original from 1923. It specifically describes this road as private property with explicit reservation of all access rights. I can get it right now." "Please do," Deputy Johnson said. I jogged back to my house, retrieved the deed from the safe where I had stored it, and brought it back. Deputy Johnson examined it carefully, taking his time to read the relevant passages. Then he looked at Patricia's tablet again, zooming in on the alleged county document. "Madam, this document you're showing me doesn't match the county's mapping style from that era," he said. "The font is wrong, and the reference markers aren't consistent with county surveying standards from 1919. "Where did you obtain this?" Patricia's face flushed. "It was provided by our property research consultant. It's a certified copy of county records." "What's the name of this consultant?" "I don't have that information with me." "You don't have the name of the person who provided your legal documentation?" Deputy Johnson's tone was skeptical now. "Madam, I've looked at hundreds of historical property documents in this county. This doesn't look legitimate to me." "Mr. Yates, on the other hand, has an original deed with clear language establishing private ownership of this road." "We have a right to investigate potential easements," Patricia insisted. "Not by trespassing on private property, you don't. If you believe you have a legitimate claim to an easement, you need to pursue it through proper legal channels. You can't just show up on someone's property with questionable documentation and demand access. I'm going to have to ask you all to leave." "This is outrageous," Patricia sputtered. "We're going to file a complaint." "That's your right, madam. But right now, you need to leave this private property. If you refuse, I can cite you for criminal trespass." That got through to them. Robert Chambers was already walking back toward a BMW parked further down the road. The woman with the tablet followed quickly. The young guy with the camera hesitated, clearly wanting to capture more drama, but Patricia finally gave in and stalked off, throwing angry looks over her shoulder. After they were gone, Deputy Johnson turned to me with a sympathetic expression. "You're going to have more problems with these people," he said. "I've dealt with HOA disputes before. They can get ugly. Document everything. Every interaction, every phone call, every letter. Keep copies of all your property records, and if they show up on your property again, call us immediately. Don't engage with them yourself." "I appreciate your help," I said sincerely. "That deed of yours is rock solid. I'm not a lawyer, but I've seen enough property disputes to know clear language when I see it. They're not going to win this through legal channels, which means they might try other tactics. Be careful." His warning proved prophetic. Over the next 2 weeks, I experienced what I can only describe as a harassment campaign. It started small. Phone calls at odd hours from blocked numbers, hang-ups when I answered. Then escalated to nastier tactics. Someone filed an anonymous complaint with the county building inspector, claiming I had unpermitted construction on my property. The inspector, a tired-looking man named Dave who clearly had better things to do, came out and found nothing wrong. He apologized for wasting my time and admitted they had been getting a lot of frivolous complaints lately. Then someone reported me to the state environmental agency, claiming I was dumping hazardous materials on my property. Another inspection, another exoneration, another apology. The environmental inspector was less patient than Dave had been. She told me bluntly that filing false reports was a crime, and that if I knew who was behind it, I should consider pressing charges. I had suspicions, but no proof. Patricia Hendricks seemed the obvious culprit, but I couldn't prove she was behind the anonymous complaints. My security cameras showed no one approaching my property, and the phone calls came from untraceable numbers. Rachel advised me to keep detailed records of everything, which I did. I created a timeline of events, saved every letter and email, and backed up all my security footage to cloud storage. If this went to court, I wanted to be prepared. The legal battle officially began in late April when Sterling, Whitmore and Associates filed suit in Franklin County Superior Court. The complaint was 47 pages of legal gymnastics, essentially arguing that my refusal to grant an easement was unreasonable, that the historical deed language should be interpreted in light of modern property law, and that the HOA's property owners were being irreparably harmed by my obstinacy. Rachel filed our response 2 weeks later, a devastating 32-page document that methodically destroyed every argument they had made. She cited the explicit deed language, historical precedent for private road rights, and pointed out that the HOA had created their own problem through negligent due diligence. She also filed a counterclaim for harassment and requested sanctions against the HOA for bringing a frivolous lawsuit. The judge assigned to the case was the Honorable Margaret Chen, a no-nonsense jurist with a reputation for efficiency and intolerance of legal theatrics. The initial hearing was scheduled for early June. In the meantime, the harassment continued but evolved. I started receiving certified letters from the HOA demanding I maintain community standards on my property. These were absurd. They wanted me to paint my house a specific shade of beige, remove the unsightly woodpile next to my workshop, and cut down several mature oak trees that allegedly violated their view corridor requirements. Each letter referenced the Meadowbrook Heights CC and Artiques as if I were bound by them. Each letter threatened fines and legal action. I forwarded them all to Rachel, who added them to our growing evidence file. "They're trying to establish that you're part of their association," she explained when I called her after the 5th such letter. "If they can get you to comply with even one of their demands, they'll argue that you've accepted the HOA's authority. Don't respond to these letters directly. Don't engage with them at all. Let me handle everything." "This is insane," I said. "How is any of this legal?" "It's not. That's why we're going to win. But you have to be patient and let the process work." Patience was not my strong suit, but I tried. I focused on my work, building a beautiful cherry dining table for a client in Boston and starting plans for a commissioned bedroom set. The physical work of cutting, sanding, and shaping wood was therapeutic, a counterbalance to the legal stress. But the HOA wasn't done. In mid-May, I discovered that someone had filed a false deed with the county recorder's office, claiming an easement across my property. The document was a sophisticated forgery, using my great-grandfather's name and a fabricated date of 1925. It purported to grant perpetual access rights to the Meadowbrook Properties Corporation for the sum of $1. I only found it because Rachel had set up a monitoring service that alerted her to any new documents filed against my property. She called me immediately, her voice tight with anger. "This is fraud," she said. "Whoever filed this committed a serious crime. We need to report this to the district attorney's office right away." We drove to the Franklin County DA's office that afternoon with the forged document, my original 1923 deed, and a detailed timeline of the HOA's escalating behavior. The assistant district attorney who met with us was a sharp-eyed woman in her 30s named Lisa Brennan who listened to our story with growing interest. "This is definitely criminal," she said, examining the forged deed. "The question is proving who did it." The document was filed electronically, which means there should be a digital trail. I'll need to get a warrant for the HOA's computer records and emails. That'll take a few days. In the meantime, what do? I asked. "This fake deed is now part of the public record." "Does that give them any legal standing?" "No," Rachel said firmly. "A forged document has no legal validity. We'll file a motion to have it removed from the record immediately, but this strengthens our case tremendously. The judge is going to see this pattern of harassment and fraud, and it's going to influence her ruling." The preliminary hearing in early June was my first time seeing Patricia Hendricks and her legal team in a courtroom setting. Sterling, Whitmore and Associates had sent their lead attorney, a silver-haired man named Douglas Whitmore, who carried himself with the confidence of someone who rarely lost. Patricia sat behind him with several other HOA board members, all dressed in business attire and wearing identical expressions of smug certainty. Judge Chen entered, and we all rose. She was a small woman with steel gray hair and piercing eyes that seemed to assess everyone in the room instantly. She sat, invited us to do the same, and got straight to business. "I've reviewed the initial filings in this case," she said. "Mr. Whitmore, your clients are seeking to compel Mr. Yates to grant an easement across his property to provide access to certain lots in your development. Is that correct?" "Yes, Your Honor," Whitmore said, standing smoothly. "The Meadowbrook Heights development consists of 52 residential lots, 3 of which cannot be practically accessed without crossing Mr. Yates's property. We attempted to negotiate a reasonable easement agreement, offering substantial compensation, but Mr. Yates refused to even consider our proposal. His intransigence is preventing legitimate property owners from accessing and developing their land, causing significant financial harm." "Miss Zimmerman," Rachel stood, and I noticed she had a slight smile on her face. "Your Honor, Mr. Yates's property has been in his family since 1923. The private road in question was specifically reserved as private property in the original deed, with explicit language preventing any easements or rights of way. The HOA's development company failed to secure proper access rights before selling those lots, creating their own problem. Mr. Yates has no legal obligation to solve it for them." "I've seen the 1923 deed," Judge Chen said. "The language is remarkably clear. Mr. Whitmore, how do you address the explicit reservation of rights in the original conveyance?" Whitmore didn't miss a beat. "Your Honor, we argue that such archaic language should be interpreted in the context of modern property law and contemporary standards of reasonable use. Property rights are not absolute when they prevent the reasonable use of neighboring land. The doctrine of necessity. The doctrine of necessity applies when property is landlocked through no fault of the owner," Judge Chen interrupted. "In this case, the HOA's development company created the landlocked condition by selling lots without secured access. That significantly weakens your position. We believe the historical evidence shows that the road was intended for general use," Whitmore continued. "The language about it being a carriage road suggests it was meant for public conveyance." "Carriage road meant a private road wide enough for a horse-drawn carriage," Rachel interjected. "The term has a specific historical meaning. It doesn't imply public use. In fact, the deed explicitly states the opposite." Judge Chen held up a hand. "I've read the deed language, counsel." "Is there anything else material to this preliminary hearing?" Rachel stood again. "Yes, Your Honor. We need to address the pattern of harassment and fraudulent activity by the HOA. Mr. Yates has been subjected to anonymous complaints, threatening letters, and most seriously, someone filed a forged deed claiming easement rights across his property. The Franklin County District Attorney's Office is investigating this forgery. That got everyone's attention." I watched Patricia's face go pale, and the HOA board members behind her started whispering urgently to each other. Whitmore's confident expression finally wavered. "Your Honor," he said carefully, "we have no knowledge of any forged documents. If someone committed forgery, it was not authorized by my clients. But someone in your client organization likely had access to the information needed to create a convincing forgery," Rachel said. "Who else would have motive to file a fake easement deed?" This is part of a pattern of escalating harassment designed to force Mr. Yates to give up his legal rights. Judge Chen looked at Whitmore with an expression that would have made a lesser attorney flinch. "Mr. Whitmore, I suggest you speak with your clients about this forgery. If the DA's investigation leads back to anyone associated with the HOA, this court will take that into consideration. As for the primary issue, I'm prepared to rule on the preliminary injunction. Based on the clear language of the 1923 deed and the HOA's failure to secure proper access before selling those lots, I'm denying the request to compel an easement. Mr. Yates has explicit historical rights to keep his road private. The HOA needs to find an alternative solution for accessing those 3 lots. Your Honor, that will impose an extreme financial burden on my clients," Whitmore protested. "Building an alternative access road would cost hundreds of thousands of dollars." "Then perhaps they should have thought of that before they sold the lots," Judge Chen said dryly. "This hearing is adjourned. I'll issue a written order by Friday." We walked out of the courthouse into the bright June sunshine, and I felt like I could breathe properly for the first time in months. Rachel was practically glowing with satisfaction. "That went even better than I hoped," she said. "Judge Chen clearly has no patience for their arguments. This isn't over yet, but we just won the most important battle." Across the parking lot, I could see Patricia Hendricks arguing vehemently with Douglas Whitmore, gesturing angrily while he tried to calm her down. The other HOA board members looked shell-shocked. I felt a moment of sympathy for Whitmore. He was just doing his job, but his clients had put him in an impossible position by bringing a weak case built on even weaker facts. The DA's investigation moved faster than I expected. Within 2 weeks, Lisa Brennan called Rachel to inform us they had traced the forged deed to a computer at the Meadowbrook Heights HOA office. The electronic filing had been submitted using Gerald Morrison's login credentials, though the investigation suggested his password had been stolen or shared. They brought Gerald in for questioning, and according to Lisa, he cooperated fully. He admitted that Patricia Hendricks had pressured him to find a solution to the access problem, but he swore he hadn't filed the forged deed himself. He claimed his computer password had been written on a sticky note in his desk drawer, and several people had access to the HOA office. The investigation expanded. The DA's office obtained warrants for email records and phone logs for all the HOA board members. What they found was damning. Patricia Hendricks had sent dozens of emails discussing various strategies to pressure me into granting the easement, including some that suggested creative solutions to establish HOA authority over my property. One email exchange in particular caught the investigators' attention. Patricia had written to another board member named Brenda Sullivan about documentation that could support our position regarding historical access rights. Brenda had responded with the name and phone number of someone she described as a document specialist who could recreate historical records based on oral history and property research. That specialist turned out to be a disbarred attorney named Martin Keach, who ran a side business creating what he called reconstructed historical documents for estate planning and property disputes. In reality, he was a forger. The DA's office raided his home office and found templates, historical paper stock, and a collection of antique typewriters used to create convincing fakes. Martin Keach was arrested on multiple counts of forgery and fraud. Under questioning, he admitted that Brenda Sullivan had hired him to create the 1925 easement deed, providing him with copies of my great-grandfather's signature from public records and specific language to include. He had been paid $5,000 in cash for the work. In late July, Patricia Hendricks and Brenda Sullivan were arrested and charged with conspiracy to commit fraud, forgery, and filing false documents with a government office. The arrests made the local news, and I suddenly found myself fielding calls from reporters wanting to know about the HOA deed forgery case. I declined most interviews, but I did speak with a reporter from the Hampshire Gazette who seemed genuinely interested in the property rights issues rather than just the scandal. The article that ran was balanced and thorough, explaining both the legal dispute and the criminal charges. It included the phrase, 1923 deed explicitly protected owners' private road rights, which gave me a certain satisfaction. The criminal case moved slowly through the system, but the civil case resolved much faster. Judge Chen issued a comprehensive ruling in August that not only denied the HOA's claims, but also granted our counterclaim for harassment. She ordered the Meadowbrook Heights HOA to pay my legal fees, totaling nearly $45,000, and issued a permanent injunction preventing them from contacting me, filing complaints about my property, or making any further claims regarding my private road. Her written opinion was scathing. She described the HOA's actions as a systematic campaign of harassment designed to coerce a property owner into surrendering clearly established legal rights. She noted that the explicit and unambiguous language of the 1923 deed leaves no room for interpretation regarding the private nature of the road in question. And she concluded that the HOA's development company had been grossly negligent in failing to secure proper access rights before selling landlocked lots, creating a self-inflicted problem, which they then attempted to solve through improper means. Douglas Whitmore personally called Rachel to discuss the fee payment. He sounded exhausted. My firm is withdrawing from further representation of the Meadowbrook Heights HOA. This case was a disaster from the beginning, and we should have advised our clients more strongly against pursuing it. The check for Mr. Yates's legal fees will be issued within 10 days. The criminal trial for Patricia Hendricks and Brenda Sullivan took place the following spring. I attended as a witness, though I only had to testify briefly about the timeline of events and the impact of their actions on my life and property. The real star witnesses were Martin Keach, who had taken a plea deal in exchange for testifying against his clients, and the forensic computer expert who traced the forged deed filing back to the HOA office. Patricia was defiant throughout the trial, insisting she had done nothing wrong and was only trying to protect the interests of the homeowners who had purchased lots in good faith. Her attorney tried to argue that she had been misled by bad advice and hadn't understood the legal implications of her actions. The jury wasn't buying it. Both Patricia and Brenda were convicted on multiple counts. Patricia received a sentence of 18 months in prison and 3 years probation, plus restitution to me for damages. Brenda received 12 months and probation. The sentences seemed light to me, but Rachel explained that white-collar crime often resulted in shorter terms, especially for first-time offenders. Gerald Morrison, who had cooperated fully with investigators, was not charged criminally, but resigned from the HOA board. I actually felt bad for him. He seemed like a decent guy who had gotten caught up in Patricia's aggressive schemes. The Meadowbrook Heights development eventually found a solution to their access problem, though it cost them dearly. They negotiated with the property owner on the other side of their lots, an older farmer named Donald Price, who was happy to sell them a strip of land for an access road at a significantly inflated price. I heard through the grapevine that it cost the HOA more than $300,000 to build the new road, money that came from special assessments on all the homeowners in the development. Robert Chambers, the buyer of Lot 47 who had confronted me that day with Patricia, ended up suing the HOA for fraud and misrepresentation. He settled out of court for an undisclosed sum, but I heard he recouped his purchase price, and then some. The other lot buyers made similar claims, further draining the HOA's finances. The Meadowbrook Heights development never quite recovered from the scandal. The lots that had been sold were eventually developed and homes built, but the reputation damage was severe. Several planned phases of expansion were canceled, and the development remained smaller than originally envisioned. Property values in the development actually decreased while values in the surrounding area, including my property, continued to rise. Life gradually returned to normal. I finished the cherry dining table and the bedroom set, both of which turned out beautifully. I took on new commissions and even expanded my workshop, adding a dedicated finishing room. The legal settlement money covered my legal fees with some left over, which I used to repave my private road, a fitting conclusion to the whole mess. I also started a relationship with Lisa Brennan, the assistant district attorney who had prosecuted the case. We had stayed in touch after the trial, initially just to discuss the case details, but conversations evolved into coffee meetings and then proper dates. She appreciated my straightforward approach to life and my craftsmanship. I admired her intelligence and dedication to justice. By the following summer, she had moved into the farmhouse with me. The 1923 deed now hangs in a frame in my workshop, a reminder of my great-grandfather's foresight and the importance of clear property rights. The language that Frederick Yates negotiated more than a century ago protected not just a road, but a principle. That property ownership means something, that rights clearly established should be respected, and that no amount of pressure or manipulation should force someone to surrender what is legally theirs. I occasionally drive past the Meadowbrook Heights development on my way to town. The entrance sign is starting to look weathered, and some of the homes seem a bit tired already, despite being only a few years old. My farmhouse, built in 1923 and lovingly restored, has never looked better. The old oak trees that the HOA wanted me to cut down are magnificent in every season, and my workshop produces furniture that will last generations. Deputy Marcus Johnson stops by every few months, usually with some excuse about checking on things in the area, though I think he just likes looking at my woodworking projects. He still talks about that day he responded to the trespassing call, how obvious it was from the beginning that the HOA was in the wrong, but how impressed he was that I had the documentation to back up my position. Most people would have just given in, he told me once. The pressure, the legal threats, the harassment, it wears people down. They figure it's easier to compromise than to fight, but you stood your ground and you were right to do it. He was correct that most people would have given in. The HOA was counting on that. They had steamrolled other property owners before with their aggressive tactics and had gotten used to getting their way. Patricia Hendricks had built a reputation as someone who always achieved her objectives, no matter what it took. She had probably never considered that this time would be different. The turning point was that 1923 deed. Without that explicit language, the case would have been much harder to win. Easement law is complex, and judges have significant discretion in deciding what constitutes reasonable use of property. If my great-grandfather had not insisted on that specific clause protecting the road's private status, I might have been forced to grant at least a limited easement. I think about Frederick Yates sometimes, wondering what prompted him to demand such protective language. Did he have a contentious neighbor? Had he seen property disputes tear apart other families? Or was he simply a careful man who believed in protecting what was his? I will never know, but I am grateful for his foresight. The story got some attention in property rights circles. Rachel told me she had been contacted by several other attorneys handling similar cases, wanting to know the details of how we had won. The explicit deed language became a template that some attorneys now recommend to their clients when drafting property conveyances. My case was even cited in a property law textbook revision as an example of how historical deed language can protect modern property rights. I gave a talk at the local historical society about the case, focusing on the importance of preserving historical documents. The attic box that had held the 1923 deed also contained dozens of other family papers, photographs, letters, and records that provided a fascinating window into the past. I donated copies to the Northampton Historical Society, keeping the originals secure in my safe. The Historical Society was particularly interested in the documents related to the construction of the road itself. My great-grandfather had kept meticulous records, receipts for materials, notes about the work, even photographs of the road at various stages of construction. Those photos, faded and fragile, showed the road as a dirt track through virgin forest, then with grading and drainage work, and finally with the first application of gravel. The care and labor that went into building that road made it all the more important to preserve it as private property. I also discovered letters my great-grandfather had written to his brother describing the property purchase and his plans for the land. In one letter from 1923, he wrote, "I have negotiated terms that will protect this land for our descendants. The road I am building will serve the family for generations, and I have ensured that no one can take it from us or claim rights to cross our property without permission. This is important, brother. Land is not just dirt and trees. It is legacy." Reading those words gave me chills. Frederick Yates had understood exactly what he was protecting, and his legacy had endured for exactly as long as he had hoped. I was the latest generation to benefit from his foresight, but I would not be the last. The property was held in a trust now, with provisions to keep it in the family for the foreseeable future. Lisa and I talked sometimes about having children, about the farmhouse echoing with young voices again as it had when my father and grandfather were boys. The workshop would be a great place for kids to learn craftsmanship, to understand the value of creating things with their own hands. The woods were perfect for exploration and adventure. And yes, the private road would be there for them too, a tangible connection to their great-great-great-grandfather's determination to protect what was his. The legal profession learned some lessons from the case as well. The Massachusetts Bar Association published an ethics bulletin warning attorneys about the dangers of pursuing cases built on weak legal foundations, noting that aggressive tactics do not substitute for solid legal arguments. They specifically mentioned the Meadowbrook Heights case as an example of how attorney pressure on behalf of a client can cross ethical lines into harassment. Douglas Whitmore retired shortly after the case concluded. I heard through Rachel that he had been increasingly uncomfortable with the aggressive tactics some HOAs and developers expected their attorneys to employ. The Meadowbrook Heights disaster had been the final straw. He now taught property law as an adjunct professor at a law school in Boston, using his own cases, including mine, as cautionary examples. Sterling, Whitmore and Associates quietly dropped all HOA clients from their practice. The remaining partners issued a statement saying they would focus on collaborative property solutions rather than adversarial approaches. Whether that was genuine philosophy or just damage control, I did not know and did not care. They had learned an expensive lesson about choosing their clients and cases more carefully. As for the Meadowbrook Heights HOA itself, it underwent significant restructuring after the criminal convictions and lawsuits. A new board was elected, led by a retired professor named Elizabeth Norton, who had a completely different approach. She reached out to me once, not to ask for anything, but simply to apologize on behalf of the community for what had happened. We met for coffee in Northampton, and I found her to be genuine and thoughtful. She explained that most of the homeowners in the development had been appalled by what Patricia Hendricks had done, and that the new board was committed to operating with transparency and respect for neighboring property owners. "What happened to you was inexcusable," Elizabeth said. "We want to be good neighbors, not antagonists. If there is ever anything we can do to make amends, please let me know." I appreciated the gesture, and we parted on good terms. True to her word, the new HOA board operated quietly and caused no problems. They focused on maintaining their own community without trying to extend their reach beyond their legitimate boundaries. It was how an HOA should have operated from the beginning. The buyers of the 3 lots that had caused all the trouble eventually built their homes, accessing them via the expensive new road the HOA had been forced to construct. I drove past them once out of curiosity. They were nice enough houses, standard suburban designs that would not have looked out of place in any development across America. Nothing special, nothing worth the legal battle and criminal charges that their mere existence had triggered. Robert Chambers, after settling his lawsuit, sold his lot and moved to Vermont. I heard he wanted nothing more to do with HOAs or developments after his experience. I could not blame him. He had been caught in the middle of a situation, not of his making, a victim of Patricia Hendricks's negligence and fraud. At least he had been made financially whole, though the stress and aggravation could not be fully compensated. On quiet evenings, I sometimes walk down my private road just to appreciate it. The pavement is smooth and well maintained, the drainage ditches clear and functional. In summer, the overhanging branches create a green tunnel that filters the late afternoon light into dancing patterns. In fall, the oak and maple trees turn brilliant colors, carpeting the road with leaves. In winter, I keep it plowed, and the snow banks on either side create a pristine white corridor through the forest. This is what my great-grandfather built. This is what the HOA tried to take. And this is what the 1923 deed protected. Sometimes the right words, written at the right time, can echo down through the decades to protect the rights of people not yet born. Frederick Yates put those words in his deed, and a century later they stood up to legal challenges, fraudulent schemes, and the pressure tactics of people who thought they could bully their way to what they wanted. The road remains private. The property remains protected, and the legacy continues. I think about alternate timelines sometimes, wondering what would have happened if I had not found that deed in the attic, if I had simply taken Rachel's advice to look for historical documents, but come up empty-handed. The case would have been much harder to win without that explicit language. I might have been forced into a compromise easement, limited to certain uses and times perhaps, but still an intrusion on property that had been exclusively private for a century. Or worse, I might have given in to the pressure before it ever reached court. The harassment campaign, the legal threats, the anonymous complaints, they all could have worn me down to the point where I accepted the HOA's offer just to make the stress stop. $25,000 might have seemed like a reasonable price for peace of mind. But I had found the deed, and the deed changed everything. It transformed the case from a murky property dispute into a clear-cut question of explicitly protected rights. Judge Chen had not needed to interpret ambiguous language or balance competing interests. She simply read the words Frederick Yates had negotiated in 1923 and applied them to the modern situation. The law working exactly as it should. That is what property rights mean, I realized. Not just the physical control of land and buildings, but the legal certainty that what is yours cannot be taken from you without your consent or due process. Patricia Hendricks had tried to circumvent that certainty through fraud and intimidation. The legal system, for all its flaws and delays, had ultimately protected those rights and punished those who tried to violate them. Now, sitting in my workshop on a cool evening in late autumn, I can hear the wind moving through the oak trees and the occasional car passing on the highway a mile away. My property is peaceful and secure. The private road is mine, as it was my father's, my grandfather's, and my great-grandfather's. The 1923 deed, framed and protected, ensures it will remain in the family for generations to come. The HOA learned the hard way that some battles are not worth fighting, especially when you are clearly in the wrong. Patricia Hendricks sits in prison, her reputation destroyed, paying the price for thinking she could forge documents and intimidate her way to what she wanted. The Meadowbrook Heights development bears the financial and reputational scars of her actions. And I continue building furniture, working with wood, living the quiet life I always wanted on land that has been in my family for over a century. The 1923 deed protected more than a road. It protected a way of life, a connection to the past, and the fundamental principle that property rights matter. That is the story of how an HOA demanded access to my private road and went quiet when I showed them the 1923 deed. It is a story about standing firm in the face of pressure, about the importance of historical documents, and about how the right words written a century ago can still protect property rights today. It is also a story about the consequences of fraud and the importance of the legal system in protecting individual rights against organized pressure. The oak trees Frederick Yates left standing when he cleared the land for his road are taller now, their branches reaching toward the sky, their roots deep in the Massachusetts soil. They have witnessed a century of family history, and if they last another century, they will witness more. The road winds beneath them, private as it has always been, protected by foresight and law, a legacy that continues.